If you're looking for the real help, babybar.online.
Hello, this is a BP Learned Hand. I'm here tonight with my significant other. We decided to do this because I think sometimes it's easy for us to forget that we have significant others. So, in an attempt to figure out what we were going to talk about tonight, because I'm sure you all know how it is, and you have significant others, you have to find a way to make sense of your relationship with the law, because she is a jealous mistress, and your significant watch your language. So what I thought would be fun for us to do would be to take a look at what I call the banana negligence essay. Well, it is. It's banana negligence.
Tropical five.
Well, it's banana negligence. So,
Tropical five.
all right. So this is a question off the first year law students exam. And there's 3 calls to the question. There's 3 body paragraphs, basically. The last paragraph is really just trying to figure out the call of the question, telling you specifically what you need to do an analysis on.
Yeah.
All right. So in the first paragraph, you have a child, 4 years old, he's seated in a shopping cart. Her mother was using at the shopping market. While mother was distracted with her shopping list, child took a banana from a display counter, took a bite out of it, peel and all. Child swallowed the bite she had taken and threw the remainder of the banana onto the floor.
Littering.
Eventually, the child became very ill from a toxic substance the banana supplier had sprayed on the banana skin. Delivery before before the delivery of the bananas to the market. So that's the first. But that's like essentially the first claim. The first call says a child's lawsuit against the market. We're told that the child's bringing claim for strict liability. So that's what happened.
Yeah. Why is this market selling toxic bananas in the first place?
Well, that's kind of the question you have to ask yourself, though.
Do they know they're toxic bananas?
Well, I don't know. They don't tell us whether or not they know.
No one knows they're selling doomsday bananas?
Well, no, I don't know.
How many other people bought these doomsday bananas?
Well, they don't tell you. They don't tell you. They just tell you the kid became really ill because of a toxic substance. And so we have to look at
a town full of dead banana eaters.
Well, maybe it's just the one banana. You don't know. So we have to look at it, right? So we're told that the child brings a claim for strict liability. Strict liability. So you've probably heard me talk enough about this. You should have some kind of idea. So strict liability, I mean, we're talking dangerous animals. I don't think a banana is a dangerous animal.
No,
and then we've got
no, it's not.
Dangerous activities.
I don't think eating a banana should be a danger. I guess it could be.
Well, wouldn't spraying the banana be a dangerous activity?
Well, yes, spraying. Yeah, I guess. Yeah, I suppose spraying bananas and anything to do with pesticides is dangerous. I used to be a chemical soldier in the Army, folks. So yeah, toxic chemicals bad.
So so you have dangerous animals, dangerous activities.
But I want to interrupt.
Again.
Yes, I'm going to do that. I mean, it's a banana in a store. That should not be dangerous.
Yeah, but it could be.
But nobody knows that.
Well, that's the whole point, though.
Like if you go walking around telling everybody, "Hey, folks, your cornflakes could take out your eyes," no one's gonna eat cornflakes anymore. First off, second, that should come with a warning label. Like the cigarettes I smoke have a warning label on it.
Yes, but see, that's the thing, though. That's strict product liability.
Okay.
So when you sue in strict product liability,
yes,
you have to have proper parties.
Okay.
And you have to have a defective product.
Banana.
And the banana is defective.
The doomsday banana.
So either you have a defective design defect, manufacturing defect, or failure to warn.
All right.
So, yes, if they are in fact doomsday bananas, they should in fact have a warning, or they should probably be made differently.
Chernobyl banana.
They should be made differently.
They should be made differently.
All right, but there's more to this. It's not just the banana Okay, this is banana negligence, okay?
Okay.
All right. Second paragraph of this. So
Chiquita bananas are too expensive. We're going to go with Chernobyl brand.
okay, so second part. Shopper slipped on the banana. Just wait. So child slipped on the banana. No, you got me all messed up now. Shopper slipped on the banana that the child had thrown onto the floor. fell against the shopping cart he was using. As he fell, he hit his face on a sharp edge protruding from the shopping cart, severely injuring his eye.
So you're telling me that whatever this marketplace is, they sell Chernobyl bananas and issue spiked shopping carts,
Yes.
and no one cleans the floor.
Well, I mean, I guess the kid just threw it, but we don't. I mean, I don't know. It doesn't have like a timestamp on it or anything.
All right.
I mean, the banana could have been there for a second. It could have been there for, I don't know, hours. But they don't tell us that.
So Indiana Jones slid across the produce aisle
He could have been.
to snatch the Chernobyl banana out of the child's hand and slipped on the Chernobyl banana and impaled himself
In his
on
eye.
a punji pit cart.
Yes.
Okay.
Possibly.
This is terrible.
Possibly. But that's okay because the second call of the question asks us, what are the shopper's lawsuits against the market? And we're told that the shopper brought a strict liability claim. So once again, we're in strict liability, which are the animals, dangerous activities, and then strict product liability or negligence per se, which we don't have any statutes, so we don't have that. So,
All right.
so we've got to talk about, is this a inherently dangerous activity, the pushing of shopping carts? I wouldn't even get into that because I don't think that's just not dangerous.
I wouldn't.
Pushing of a shopping cart.
I wouldn't think so. No, I do it
But he
every
didn't,
other day. I've never impaled myself on a shopping cart,
and you are very clumsy.
and I am extremely clumsy.
I've never seen you. So do you want to hear the third call, the third paragraph?
Okay.
There's a third paragraph. Now, Polly, a police officer,
Okay.
which is funny,
Yes.
who was off duty and doing her personal shopping, saw Shopper fall and ran to his aid. Polly slipped on the banana that the child had thrown onto the floor, and as Polly fell, she came into contact with the sharp edge of the same shopping cart that Shopper had used.
I feel that this banana was summoned to our realm by a satanic call.
Polly's arm was seriously cut as a result. So now everyone's bringing suit, and they're all bringing it on strict liability.
This is this market manager's worst possible day.
This is the banana that should never have been.
Okay.
So this kid comes in the store, eats a banana, gets sick.
Throws banana on floor.
Yes, Shopper slips on banana, impales himself on Punji Pit shopping cart, and then Polly the police officer rushes to her aid and slips on same banana and impales her
So
arm
this banana gets
on.
around.
Yeah, it's a busy banana. That's why I call it banana negligence. It's a negligent banana.
Ridiculous, evil banana.
Yes.
All right, so me being not a lawyer
At all.
and instead a entomologist guy,
I'm not a lawyer either. I'm just a law school student.
having no experience with law school outside of trying to live through it.
You can't take the banana to court, so.
Yeah, well, I would want to go back to, did the market even know that they were selling a toxic banana?
You're more strung up on this toxic banana issue.
Well, okay, so all of this happened because of this malevolent banana that was sitting there waiting to destroy humanity.
Well, God, imagine what happened next.
It was voted in as president. No. I want to know, is the market liable? Like, is it
For
their
the
fault?
toxic banana?
Yeah, is it their fault that they sold the toxic banana? Because I guess somebody somewhere along that produce chain would have to know that it's sprayed in toxic chemicals, but
Why would they have to know, though? That's the thing, is that we're not told that. That's the thing with law schools. We can't infer any of that. It's probably why you hate arguing with me. Is
Yeah.
like, you didn't tell me that. You can't say
Yeah.
that I knew.
Yeah.
Well, because they don't tell us that. So, like, you have to bring a claim, and this is where it all depends comes from, that obnoxious phrase that it all depends. I mean,
I hate that.
you have strict product liability in tort. You know, you've got to, I mean, I'm showing him on the screen, by the way, the model answer.
There's some nonsensical gobbledygook.
Well, it's not nonsense. I mean, if
Yeah,
you look
all
at
right.
it, look, there's the heading. Okay, that's the heading. And then underneath that's the rule statement.
Torts sound tasty.
They are tasty, I think. I don't honestly know what a tort is anymore. I've Googled pictures and they look delicious. But anyway, so strict product liability. I think there is a good case for strict product liability.
But how?
Against the store, because okay, so this is the way it works. Strict
Like-
product liability, anybody So you have to have proper parties, right? So
Yeah.
anybody who uses or is a foreseeable bystander is a proper plaintiff. A proper defendant is anybody who manufactures, distributes, franchisors, anybody that puts it into the chain of commerce.
Okay.
So the market's putting this crazy ass banana onto the chain of commerce. I'm gonna have to bleep this. And then the kid's eating it because he's there,
Yeah,
he's in the chain
yeah.
of commerce, he's a foreseeable bystander.
Yeah.
So we have proper parties. Now the next thing you have to prove in your case so that this sick banana eating kid wins is that there was some kind of defect. So maybe there was a design defect, or maybe there's a defective warning.
Well, I would say
or-
the banana being covered in toxic, you kill you dead chemicals, that's probably pretty defective, I would think. My question then is, so if the store is getting sued, can the store sue its supplier for selling them a uncleaned
Yes.
doomsday banana?
Yes, they can bring them in. That's joinder, but that's 2L stuff. They can bring them in. I mean, there's
Okay,
I mean,
because
there's joined
otherwise it
several
just
of-
does
there's
not. It just doesn't seem fair to me.
no, it's not. But that's kind of how we always have this conversation about how America's built like all of our laws around this chain of commerce idea and keeping commerce flowing.
Like
and-
I talked to Wade, Wade's the guy who runs our local grocery store. He doesn't keep track of every individual banana, and neither do the employees.
well, you can't. Well, I mean,
you can't. There's hundreds.
well, we have 7 kids, so imagine if we had gone to a grocery store after Halloween and just let them run rampant.
Oh yeah,
It's-
Sugar Owl would be.
Oh yeah, it would be worse than just banana
Yeah.
peels. I mean, it'd just be horrible.
Detroit violence.
Yeah. Well, but see, that's where causation comes in, though. And you have to show actual, which is but for something cause,
Okay.
and then proximate cause, which is there was a foreseeability factor there.
But could the store foresee that their bananas would be murder on children?
Well, and see, that's the thing is you have to discuss that. I mean, is it foreseeable that a banana? I mean, I personally have never eaten banana peels, but I have heard people smoke them.
I don't. What?
Yeah, I have. I've heard people smoke banana peels to get high. So imagine.
Goddamn desperate.
Yeah, it's stupid. I never said it wasn't stupid, but imagine if you had some dumb high teenager who went to smoke a banana peel. It'd probably be way worse than just taking a bite, right?
Yeah, it would.
So I mean,
Chemicals
there's
get
got to
in
be
the
some
leg
kind
and
of
on it.
there's got to be something there for people to rely on.
Well, then, if that's the case, how come every banana that shows up at the store doesn't have a warning label on it?
Because that's what you have to argue, though. I mean, clearly, if every banana was like the banana that the kid ate, then at some point you would get whatever the chemical was on your
Yeah,
hands, and
Rub
someone
your eyes. And
you
go
rub your
blind.
eyes
Yeah.
and go blind. Something would happen. But this one banana, for whatever reason, had this poisonous chemical on it. And I think the fact pattern, if we go back to the fact pattern, it says that, let's see. Seated in the shopping market, child took a bite from the banana. Let's see. Very ill from a toxic substance the banana supplier had sprayed on the banana skin. So they intentionally sprayed it on this banana skin. So maybe it was their first shipment. Maybe this is just their first casualty of these, like, maybe they got a new banana supplier. I don't know. But those are the kind of things you have to argue, though.
Yeah.
But even if it was, I mean, think about it. From, like, a parent's point of view, even if this was, like, the first shipment of bananas and your kid to get deadly ill from doing something that, most of us would see pretty innocuous, you would still want to hold somebody liable for that.
Yeah.
And so you would go to the grocery store and you would sue them. And then the grocery store in turn would bring suit against the banana people or bring them joinder or whatever.
That makes sense.
So there has to be some kind of recompensation, or there has to be some kind of liability for somebody with this whole banana thing.
So then how do you prove it's the stores? Like, the store's at fault. How do you prove that?
Well, that's what I was showing you. Like, this is how you prove it. You have to prove the elements. Like, you know how I keep telling you there's a prima facie case and you have to, like, prove all these little bits. If you can't prove all these little bits, then you don't have a case. And, that goes to that reasonable person we argued about earlier today, is the jury is made up of reasonable people.
Sure it
who
is. Okay.
are going to look at these things and decide whether or not you proved your case, whether your prima facie case, you hit all the elements.
And how are you going to explain this to a jury? Because I don't know what the hell prima facie means.
Well, the judge is going to say these are the things you need to look at. You go to a room and then you listen, you look at what all the stuff the attorney proved, like showed you, and you say, did they show me they were proper parties? Is this plaintiff, the proper plaintiff? Was he a foreseeable user, bystander? Did he purchase the product? And then if you feel as a jury member that the attorney did a good job either showing or not showing, then you make your decision there. But you have to, it's kind of like having check boxes. You've got to go through and have all the check boxes checked before somebody's liable for it.
Okay. All right. I guess that makes sense. I've never successfully been on a jury after the time that
Nobody wants you on a jury.
I went. And
I'm surprised you're not more irritated by the punching pit grocery store, like shopping.
No, I'm getting to that. I'm still stuck on this banana thing, but I'm getting to that. I will say that the store is probably at fault for not having somebody there to go, watch out, folks, there's a deadly banana on the floor.
Well, was it
because that's just cartoonish.
Nobody.
Like if there's a banana peel on the ground, you expect cartoonish shenanigans to ensue.
This is true.
Which they did. It was a violent cartoon, but a cartoon nonetheless.
So this is the model answer. They have defenses here for this whole banana part for this
Okay.
kid. So they have contributory negligence here.
Right.
If, the plaintiff's recovery may be barred if the plaintiff knew the dangers associated with the product yet acted in a negligent manner
Well,
that
he's
was below
4.
the standard of care to protect the plaintiff.
It's unlikely he could even read the label if the banana came with a warning came from Chernobyl label.
But it didn't.
But it didn't.
And then,
if he did, he couldn't read it.
yep. And then there's also comparative negligence, which says the fault between the plaintiff and market would be apportioned evenly and distributed. So, like, if the kid was 10% responsible for buying.
Wait, there's percentages now.
Yeah,
Okay.
there's actually, yeah. Yeah, that is a defense.
What?
Remember, kids are responsible for their torts.
Little kids.
The kids are responsible for their tortious acts. We read this case about this kid.
Wait.
Okay, so you'll remember this. We read this case in 1L about this little kid who, I think it's his grandma or somebody's going to sit down in a chair, and he pulls the chair out from under, and she falls and breaks her hip, and he's liable for that.
But he's just a really dumb. What?
Well, it's battery.
Tell me the little kid is gonna
I think
get
it was
charged
like
with
6.
battery.
I think it was like 7 or something. Yeah.
That's bullshit. What?
Yeah, well, it's because, okay, so the courts have to make sure that you have the intent requirement, like volitional act, requisite intent, causation, harmful or offensive touching.
So there is no space, no wiggle room in law for, sorry, he was just a dumb kid.
Well, okay, so there's a bit of wiggle room. So 7 and under at common law, it's not like that in common law, was you're good. I think it's 7 to 14, 7 to 13, something like that, was a rebuttable presumption of a lack of capability of forming the mental intent. And then everyone 14 and up is SOL. But that was at common law. These days, totally different. Now it's all statutory.
This angers me. All right. Okay, so now I'm mad that some, 15-year-old, 16-year-old kid, hell, even a 7-year-old kid, I'm mad that a 7-year-old kid can be charged with battery legally. No, he can be charged with battery legally. But, can't go get a pack of smokes from the corner store for his mom. What the hell?
Well, don't you remember that case I was reading to you the other day about that kid who, would he hug his grandma too tight?
Yes.
And his grandma brought suit against him because she broke his arm. I don't know, something happened. Anyway, but she brought suit and tore it. Well, she had to because the insurance company wasn't going to pay for the grandma's damage.
So her grandson has 10 grand just lying around?
Well, no, the house was insured, and because the grandson lived at the house, grandma had to bring suit against the kid in order for the insurance to kick in because the insurance wasn't going to pay unless grandma brought suit. I'm not even kidding.
I think we should vote on a new law in which insurance companies are hung from the neck until dead.
This is what we deal with. This is the essay. This is the kind of nonsense that I have to deal with on a pretty regular basis. Everyone in 1L and 2L. You don't even want me to talk about property. You might just absolutely blow your brains out if you had to hear about property.
I've heard some of your property stuff. And
Yeah, it's no fun.
I strongly disagree with property law.
Well, I think property law is like talking to an English banker from the 1800s.
No, that guy's way more reasonable than your property law.
Yeah, the reasonable person does not have it in property law. Is not there. So, okay,
I
so,
tried to read your books. If nothing reasonable or prudent in them.
all right, so our shopping cart. So the next thing we have to attack is we have to attack the shopping cart issue, right? So we've got the shopping cart, we've got the shopper versus the market. Remember the lady that's
Yeah.
shopping, just minding her own business, and Benny Hill's on the banana?
Yeah.
Okay.
So I would say, as a layman, why ain't there a guy in the produce section just walking around checking out the produce, employee of the store who can go, look out, there's a banana.
Well, okay, so there are slip and fall cases. First off, we do read about slip and fall cases, but it's more difficult than just calling it a slip and fall case, because if the slip and fall case that we specifically read in 1L talks about a Cracker Barrel, now that I think about it, and somebody spilled soda or something, the lady slipped on it and she fell and hurt herself, she brought soup. Well, I think the case revolved around whether or not the soda on the ground was sticky.
That's so dumb.
Well, it's not dumb if you think about it, because if the soda was sticky, then it'd been there for a while.
Okay, I get you.
And they have a duty to maintain and keep people safe and stuff. So if the soda was sticky and it had been there for a while, then clearly nobody cared,
Yeah.
and they're
yeah.
strictly liable. But what had
I
happened
get what
was,
you're saying.
yeah,
If the kid had just thrown down the banana and
right.
it had just happened, then yeah.
But-
All right, I can see that.
Because you can't expect there to be like people hiding in like the fruit aisle like ninjas, waiting to like jump out at the moment anybody drops something, or
Walmart needs to hire more people.
well. I mean, really, that's the long and the short of it. So at this point, we don't know whether or not the banana had been there for a day, an hour, a second. They don't tell you that, because they don't tell you that stuff. Because if they did, then we would be
It'd be
dressed.
too easy.
It'd be too easy. So we're told we have to argue it.
Okay.
We have to argue like whether or not one way or the other. Because if you're a client, you come in to talk to us, and you're like, "This is the situation that happened." The first thing we're going to say is, "Do you know how long the banana was there?"
And I'm gonna go. I don't know. I want you to argue it.
If you say, "I don't know," I want you to argue it, I'm going to be like, "All right, well, you're a filthy liar. Was that banana from your purse?" But
I would know, Miss Lawyer Man. Give me that sweet, sweet law money.
the problem I have with this whole fact pattern banana negligence is not the banana. The banana is easy to address.
Okay.
The problem is the shopping cart of doom.
I guess it wasn't covered in protective foam and football pads weren't issued at the door, so.
This is why you don't want the law involved in anything, because that's what
Yeah.
happens, right?
Yeah.
Yeah.
Yeah, you guys are the reason I have to.
We're the reason that kids these
Yeah.
days have to wear helmets and knee pads and arm pads and yada
I
yada.
can't blow stuff up on BLM anymore.
Nope, can't do any of that stuff. Can't
you
shoot
guys
unless
are-
you're at a firing
you guys are
range. Yeah,
jerks.
well, we're not jerks. We're just doing it
Nope, you
analysis.
definitely jerks.
No, we're not. See, this is what I have to deal with constantly. So you guys think your life is miserable. I get called a jerk every time. But my problem with it is,
If a man breaks into your house and you own the house and you sneak up on him in the middle of the night while he's rummaging through your shit,
I already told, okay,
I think you should be able to shoot him and eat him.
I've already explained to you, you cannot use deadly force to protect your property. You can't put gin traps outside. I can't tell you how many times I've had to explain this to him. He thinks in his head, because we've got,
You made me sell all my poaching equipment.
you cannot put gin traps outside to keep people from breaking in.
They work.
Well, you just can't do it. You can't use deadly force to protect property.
I don't see why not.
Because you can't. Those are the rules.
Deadly force is a deterrent. Yelling, please leave, is not.
Well, I mean, imagine you have kids running around. I mean, the law is made the way it is. It's based off of hundreds of years of, stuff.
Of tomfoolery.
Yes, exactly. Shenanigans and goings-ons. You gotta make sure that you're keeping the shenanigans and goings-ons. It's not always people doing bad things. I mean, sometimes you have you have a good person in the wrong place. I mean, some Remember the kid that got loose, the neighbor's kid, and
Yeah.
remember he used to be all mean to us all the time, and then his kid got loose and ended up in our backyard?
Yeah.
Well, if you had gin traps out there, she might have lost a leg.
There were little gin traps. All right, I get what you're saying. The size of the gin trap.
No, I'm not
Does
saying
not
the size of
matter.
the. Okay.
I know. I understand the size of the gin trap does not matter.
It's just the fact that it is the gin trap. It's the fact that it's a trap. And, you know, you never know what's going to happen. People, I mean, what if a bus of daycare people, little daycare kids, could just break down on the side of the road and somehow in front of our house. And then the doors open to the bus and a lion shows up because one of our neighbors has a lion. I don't know. This is a very convoluted fact pattern. The kids scream and run through a yard. If we got a yard full of gin traps, we got a bunch of kids with no legs out there. And now it's all our fault. See?
First off, common sense dictates that if you're a little kid who just escaped the daycare bus, that you probably shouldn't run up to the Addams family house, jump the fence, and run through their backyard full of giant pigs and gin traps.
Yeah, but you put gin traps outside of our fence.
It was next to the fence.
Okay, so it is our land. But still, what if those kids ran through that field?
I posted signs.
That doesn't matter. Kids can't read. Telling you.
So what you're saying is visual aid.
That doesn't make it any better. There is legit an FLSC question about a guy whose land backs up to a park.
Okay.
And he gets sick of people like riding horses or something and eating his grass.
Yeah.
So he puts an electrified fence.
All right.
And he puts a sign like every 20 feet that says electrified fence. Well, some lady is riding by on a horse
Yeah.
and came in the middle of the signs, electrified her horse and died.
Well, she shouldn't have been up on his fence.
That is not how this works. What if it was a little kid? Oh my goodness, you are just.
Why is a little kid riding a goddamn horse?
You're incorrigible.
To the park.
I don't even know how long we've been doing this. All I know is you're ridiculous. Ridiculous and you're incorrigible. I don't even know what to tell you at this point.
I'd make a great one.
No, you wouldn't. You make a horrible.
Judge, I say.
You would have to be dressed.
Judge shouldn't be riding no horse.
You'd have to be dressed like Foghorn Leghorn, and even at
I
that point.
definitely would.
Oh
I would
my.
use giant red suspenders.
What are you doing? See? So now when you're walking out to the car, if you step in a gin trap, it's your own fault.
I sold them all because you kept telling me that we would be liable if somebody lost a foot.
See? And for good reason. Now I have to edit all of this.
Don't edit it. They're adults.
No, they're not. They're law school people.
They're more or less adults.
No, people in law school are not adults. We are uptight, high-strung, type A, better than everyone else in our class people.
Ouch.
He is. All right, so if you felt like this was not fine, please direct all of your commentary to my husband. I'm sure he will be more than happy to field any comments, suggestions, improvements that you have for
I'm
him,
definitely going to swear a lot, too.
which he does. You can only imagine how hard it has been to hold back on this. So this has been the BP Learned Hand discussing law stuff. I don't know what else to call this with my significant other.
Goddamn legal shenanigans.
Oh my, now I have to hear this all
Can't
night.
defend my property.
Thank you
Can't leave
for
banana
joining
peels lying
us.
around.
Next time, remember to join us on FYLSE Real Help to pass the baby bar. This
Put up your
probably won't
signs.
help you, but at least you enjoyed it. All right, we'll
Signs
talk to you
everywhere,
guys
gotta wear
later.
football pads.
Oh, he's still going. Oh my.